Welcome to Introduction to Copyrights, and today's panelist is Brett Harris. And Brett is a third-year law student at UA Little Rock's William H. Bowen School of Law. He's taken advanced intellectual property coursework as a visiting student at the University of Illinois at Chicago Law School, and he hopes to specialize in intellectual property law after graduation. Now, prior to attending law school, Brett obtained a Bachelor of Science in Management from Arkansas State University, and he's worked with a textbook distributor focusing on intellectual property issues. Take it away, Brett.
Thank you so much for that introduction, Timothy. Again, I'm Brett Harris, and I'm a Rule 15 student attorney here at the Bowen School of Law. I'm also accompanied today by Professor Kimberly Vu-Dinh, who is an assistant clinical professor at the Bowen School of Law, and she is also the director of the Business Innovations Clinic. We're really excited to have this opportunity to collaborate with ASBTDC for this four-part intellectual property workshop series. And we have one more workshop remaining after today, so we hope you'll join us for that. We're also going to be releasing toolkits as well as accompanying videos as well at the conclusion of this series. So we'll hope that you check all of that information out, and hopefully that you're going to be able to walk away with a basic understanding of the different areas of IP. For those of you not familiar with the Business Innovations Clinic, we are a pro bono legal clinic, and we focus on primarily assisting small businesses as well as nonprofit organizations with various legal matters, all with the goal of community improvement and betterment. Before we begin today's presentation, we do need to share this disclaimer, primarily that the information contained in the presentation today is for educational and informational purposes only. Anything in today's presentation does not constitute legal advice, and any interactions that we may have, whether it be through answering questions at the end of the presentation or responses that we receive during the interactive portions of today's presentation, do not form an attorney-client relationship. So before we really dive into copyrights today, I think it's always helpful to start with a roadmap of where we're headed. So we're going to start by taking a look at where we are within IP. Then we're going to dive into what exactly is a copyright. Then we're going to discuss ownership of a copyright, as well as registration, and then licensing and assignment, and then infringement, and then we're going to conclude with fair use. So with that, let's take a quick look at kind of where we are in relation to our workshop series as a whole. As you may recall, there are four major legal tools used in intellectual property, those being copyright, trademark, patent, and trade secrets. Today, obviously, we're going to be focusing on copyright, which protects original works of authorship that are in a fixed, tangible medium of expression. The other three are somewhat related, especially trademarks are often confused with copyrights. So trademarks protect identifying marks used in association with goods and services in commerce. Then we have patents, which protect inventions and underlying designs of technology, product formulations, and other useful utilitarian inventions. And then trade secrets protects certain information and assets or processes that are have economic value to the business, and the business elects to keep those a secret, and those may be eligible for trade secret protection. So with that, let's start out with our first pop quiz. Works are protectable by copyright so long as the author can articulate what the work is. And here, again, this is a true-false question. So if you would, please just reply whether you think the answer is true or false on the questions pane on the right-hand side. Okay, so here we have the answer to this is actually false, because copyright has to be actually fixed in a tangible form. meaning that it can't just be a mere idea or a concept that's in someone's head. It has to actually be recorded and fixed in a tangible medium, which we're going to talk about a whole lot more in the next couple slides. So the answer here is false. So with that, let's start with what is a copyright? Well, as we've already said, copyright protects original works of authorship that are in a fixed or tangible form. Copyrights really work by preventing others from using an author's work without authorization or compensation to the author. So here again, this is really the aspirational goal of copyrights, is to prevent others from coming in and using a work without consent or compensation to the author itself. So now we're going to kind of break this definition down across the next few slides and really dive into what each terminology or phrase of words means within the definition, starting with what is an original work. So an original work is a work that is created independently by a human author, and it has to possess at least some minimal degree of creativity. And, you know, this minimal degree of creativity is actually a really low threshold overall, because, you know, options such as simple as the author's layout, the author's choice of arrangement, and compiling information or works together or pieces of data together, that represents that minimal degree of creativity. So it's really hard to think of a situation where there is not a minimal degree of creativity present for it to be an original work. However, it is, you know, really critical that you have to have that minimal degree of creativity, and it just can't be merely copying someone else's work. So that is what we mean by when we refer to what is an original work. And, you know, the examples of compiling pieces of data together, such as with the layout and the arrangement and the compilation of the data information itself, meeting the minimal degree of creativity, that can be, you know, in the form of something as simple as developing a telephone book. And a telephone book does, in fact, meet the minimal degree of creativity. And it also is eligible for copyright as a compilation work. Even though the data is public information, the author still has to be creative in presenting the information together in a flow, in a concise and easy to understand manner. So what does it mean to be fixed in a tangible form? Well, as you saw from our first pop quiz, this is kind of a critical concept to copyright. And it just simply means that the work must be recorded in a manner so that the author can share the exact work with others. And in today's day and age, this has really changed a lot over the past several years. Whereas traditionally works, you know, might have been recorded on various mediums, whether that be paper, CD disc, DVD disc, or even, you know, the floppy disk. But now we're really moving forward to most of our data may be saved electronically in the cloud, which is essentially storing it on a server at a data center. Well, anything that is actually recorded, so long as you can share it, qualifies for being fixed in a tangible form. So, you know, here again, it can be as simple as a piece of paper, or it can be saved on an electronic form, whether on a hard drive somewhere or anywhere, as long as you're able to share the exact work with another party. So copyright really protects different types of works of authorship. And what we mean by that is that there's distinct categories that qualify for copyright protection. And these are what we refer to as works of authorship. So here we have literary works, and literary works, you know, are things such as like the Harry Potter book series. It may be poems, it can be essays, any type of written literary, any type of written work is considered a literary work. That kind of falls along those examples. So we also have musical works, and musical works are not just what you would think of as a song, but, you know, it may be the lyrics to a song, such as the lyrics to I Will Always Love You were written by Dolly Parton, which she has the copyright to the lyrics of that song. Musical works also may include compositions, so like the underlying musical composition to a song is also protectable under musical work. Next, we have dramatic works, and these include plays, Broadway musicals such as Hamilton, any type of theatrical or dramatic work really would qualify under that category. Next, we have pantomimes and choreographic works. And really, in modern time, we really see that it's primarily choreographic works that fall under this category, as pantomimes aren't that common anymore. But you still have the examples of, you know, the Nutcrackers choreography is copyrighted. Or if you joined us for our introduction to the ABCs of intellectual property presentation, you know that Beyonce's Single Ladies choreography is in fact protected by copyright. So the next category of works of authorship that are protected are pictorial, graphic, and sculptural works. And here we really want you to think of fine arts. So it can be something like a painting, it could be a sketch of something, it can be a sculpture, it can even be photography. So, you know, here we have, I list the example of Georgia O'Keeffe's Glen Canyon painting, because that's a piece of fine art that's protected under copyright still. But, you know, here, think broadly that it can be anything that's really fine art. Next, we have motion pictures and other audiovisual works. So motion pictures are typically movies. So like your Hollywood blockbuster films or anything like that that is considered a movie would be a motion picture. Now, the term audiovisual works is really kind of a broad definition, or at least broader than what I would initially have thought, because it really encompasses anything that combines audio and graphic components synced together. So a really good example of this is Martin Luther King Jr.'s I Have a Dream speech is a type of audiovisual work that is protected under copyright. Next, we have sound recordings. And sound recordings and musical works are closely related, but they are slightly different. So, for example, Whitney Houston's version of I Will Always Love You would qualify for protection as a sound recording because it is a work, but it's not the underlying components of the work itself. It's the song, that version of the song itself qualifies as a sound recording. So you can also have sound recordings of just audio speeches, recorded words, you can also have nature sounds that are recorded or things of that nature, so long as it meets the other criteria for copyright registration. Last, we have architectural works, and this is really kind of what I would call the new kid to the block, relatively speaking, because architectural works were added as a type of work of authorship for protection of copyright more recently than the other categories. And here we have, you know, a classic example of the One World Trade Center, because the design of it is very distinct and unique. So those unique features are protectable under architectural works. One thing that I do note, think is worth noting here under architectural works is that it has to be something that is a unique design element of the author themselves. And it can't be something that's really common or universally used in architecture. So, you know, a simple skyscraper being a rectangle or a square shape, that's not going to qualify for protection. But if it has a unique features added to it, those features may qualify for protection. So now you're probably thinking, wow, there's a lot of different stuff that are that's protected under copyright. And you are right, but copyright does not protect a lot of stuff as well. So here, you know, I really like to say that looking at breaking it into categories of what does copyright not protect. And you can kind of learn from these examples to get a better understanding of exactly what a copyright does protect. So here, copyright does not protect ideas, procedures, methods, systems, processes, concepts, principles, or other discoveries. So here, I give the example of a basic recipe. And a basic recipe is just that. It may be a mere list of ingredients and a basic set of preparation instructions. That's not going to qualify for copyright protection. However, if there is some degree of creativity added to it and uniqueness of the preparation, and there's enough creativeness put into the work, it might qualify. But at a basic level, a basic recipe does not. Additionally, works that are not fixed in a tangible form do not qualify for protection. So again, this is ideas or concepts that are in somebody's head, but they haven't been physically or actually recorded, are not going to qualify for protection. Titles, names, short phrases, and slogans do not qualify for protection. And here you want to think of business names, band names, things of that nature. Company slogans don't qualify for copyright protection. And slogans is kind of, that's something that's a little bit, I can see where there's some confusion there, because individuals would think, oh, that might be a literary work. But in reality, slogans are not protected under copyright, they're protected under trademarks. So there is some confusion there, but just know that, your business name and the slogan that follows it or accompanies it is generally not copyright protectable. Mere variations of ornamentation, lettering, or other stylings are not protectable. And here, this just simply means that if I go copy someone else's work verbatim, and I just change the font. Let's just say I change it from sans serif to a script font to make it look more handwritten or something like that. That's not enough. That represents just a mere copying or a mere variation. So that's not enough to get copyright protection for that specific work. Last, familiar symbols or designs are not eligible for protection. And here, when I say familiar symbols, think of things that are universally known or very commonly known to be associated with something. So, we have letters, such as like letters from the English language. Musical notation is universally known. Common patterns even. So like some examples of common patterns that would not be eligible for copyright would be like chevrons, polka dots, checkerboards, even houndstooth patterns would not be. And kind of circling back to some familiar symbols that aren't eligible for protection, you're going to think of symbols that are universally recognizable, such as the peace sign, the yin and yang sign, even the fleur-de-lis, or food labeling symbols that are included on the packaging of food products. Those symbols are universally known as well and aren't eligible for protection. So now let's take a look at a pop quiz. So true or false? You own copyright in any works you exclusively create as part of your job.
Laura's venturing a false on that. And Sandeep says false. Shanta says false.
Okay, so seems like the general consensus is false, and I would agree. It's most likely false because works that are made in connection or conjunction with employment are generally made for hire works. So in works made for hire, you don't own the copyright individually yourself, but rather the person that is paying you or contracting the work owns the copyright. So here the answer is most likely false. So kind of segueing right from that concept, you may be thinking, well, how do I know if I have a copyright? Well, basically, a copyright comes into existence at the time that the author first records the work, or it's fixed. So at the time that you first record the work so that you can share that work with someone else, that's when copyright comes into existence. But as we've already alluded to, if a work is created in the course of employment or in connection with contract labor, the work may be considered made for hire. And, you know, something that's really important to know or understand is here, you have to own the copyright in order to seek federal registration. So you can't go file for copyright protection for something that you don't own. And, you know, adding to the works made for hire a little bit, if a work made for hire, the creator or individual, like we've already said, is not the owner of the copyright, but rather the party that's paying for the work to be created. And we're going to have a whole lot more information about works made for hire in our toolkit. And our toolkit, again, is just going to be a written guide that kind of dives more in depth to these different topic areas. So keep a lookout for that toolkit, and you can learn more about made for hire works there. So can more than one person own the same copyright? And the answer here is yes, because if a work is created by more than one party with the intention of it being a single work, meaning that, you know, we intend for this to be presented as a single work, then it is classified as a joint work. Kind of similarly, but slightly different, is if a work is authored by 2 or more people, but the intent is that it's going to be separate works or separate components, then it's considered co-authored. And, you know, so an example of a joint work would be 2 people that are writing a song together with the intention of the finished product being a single work, being the lyrics to the song. So that would be an example of a joint work. An example of joint authors would be something where, you know, I author a section of a bigger research paper and someone else authors a different section of that, but we intend to maintain those sections separately. So that could be a co-authored work. And another example of this, more common, is that song lyrics are separate from the musical compositions. So if I write the musical composition to a song, it will be intended to be separate from the song lyrics itself in most cases. So what rights do you get from copyright? So you have the right to reproduce the work. And that just means that you can take your work, you can copy it, you can, you know, copy the work, share it with other people, ever how you as the copyright owner see fit. You also get the right to distribute copies of the work. So again, that goes to the step of you're sharing the work as you see appropriate. And then you also have the right to perform the work publicly. So whether that be reading your poem aloud or performing a song that you wrote, anything of that nature constitutes a live performance of the work. You also get the right to make a derivative work. And derivative works are just simply works that you take the original, they're based off of an original work, but they're modified and transformed into a new type of work that is based off of the original, and that would be a derivative work. And then last, you get the right to display the work publicly. So this is really kind of, as you can imagine, immediately what comes to mind is fine art. You can display your artwork publicly, so long as you choose to do so as the owner. And the reason why we have the bundle of sticks shown here is that you can really think of copyright as a bundle of sticks, and each stick represents a different right that you have. And you can pass out the sticks to different people, meaning that you can break apart your copyright, and someone can have that, you can give the right to reproduce the work to another party, You can give the right to display the work publicly to someone else, or, you know, if you're wanting to perform a public work, obviously, you know, think of the context of there's so many people that create cover songs that they perform live that are based off of, obviously, someone else's lyrics. Well, here again, you can give someone a stick from the bundle of sticks, giving them the right to perform your work publicly. So let's jump right into another pop quiz. So true or false? In order for a work to be protected by copyright, the work must be registered with the United States Patent and Trademark Office.
And Sandeep says that's true. And Sharita says true.
So here, this is actually false because registration is not required for a copyright to exist. You may recall me saying that copyright comes into existence at the time the work is first recorded or first fixed in a tangible form. So you can have copyright as soon as your work's created in a way that you can share the work with someone else. But you're not required to have a federal registration to have that right of copyright. But as we're going to talk about kind of across the next couple slides, registration is suggested, but again, it's not required. So with that, let's jump right into some of the benefits of registration. And here, there's several different benefits of registration. And, you know, most of them really come in the form of the rights that you, the owner, have in protecting the work to ensure that proper compensation is maintained and things of that nature, which you may recall is kind of one of the underlying principles of intellectual property as a whole, is to try to ensure that authors and inventors alike are able to monetize their creations. So here, you know, in order to pursue a federal trade or copyright infringement act, you have to have federal registration to pursue that. So that's obviously one of the bigger reasons why we recommend that you register your copyrights. But also, you know, having a registration serves as notice to others that the work is copyrighted and it's protected. So it just puts everybody, the general public, on notice that, hey, this particular matter is copyrighted, someone owns this, things of that sort. Registration also enables you to pursue judicial infringement actions, which I already referred to. So here, you can't pursue an infringement action, which is simply an action of when someone else is using your work without authorization and or compensation to the owner. That's a type of infringement, and we'll talk more about infringement later on. But just know that, you know, you have to have that registration in order to pursue an infringement action. And then also registration gives you potential access to more remedies, such as statutory damages, which is basically a set amount for an infringement that, you know, if someone infringes your work, there's a set amount in statutory damages that can be awarded for infringement. So, you know, that's always important, but also it's important to note here that in order to have access to statutory damages, you really need to have to have your registration filed prior to the infringement or within the first 3 months of first publication in order to access statutory damages or attorney's fees. But, you know, as a whole, you can kind of really see that really all the benefits of copyright registration come down to or relate back in some form or fashion to enforcement of protecting the work from others using it inappropriately. So how do you register your copyright? Well, you can actually submit the application online at the Copyright Office, and the link here is copyright.gov/registration. At the time, it will require 2 copies of your best work. or best edition being submitted to the U.S. Library of Congress for record keeping. And the best edition is just typically the edition of the work that you consider final and that you plan on distributing publicly. So how long does a copyright last? Well, this answer is somewhat complicated, but it's really gotten a whole lot more simple recently. So if the work is created after January 1st, 1978, generally the term of copyright is for 70 years after the death of the author. So another way of saying that you'll hear that stated often is life of the author plus 70 years. And that's typical for works created after January 1st, 1978. For works that were created prior to January 1st, 1978, it really varies based on several different factors. And if you have a work that was created before that date, I really recommend that you visit the U.S. Copyright Office for more information on that. Works made for hire, the term is shorter of 95 years from the first publication or 120 years from the date of creation. So works made for hire may last, kind of depending on how long the life of the author is compared to how long an author may live on a different type of work. Works made for hire may last longer or shorter than an individual work. If a work is a joint authorship, it follows that the term is 70 years after the death of the last surviving author. So that, another way of thinking about that is if you have two people that joint authored a work, one of them dies 5 years after the work was created, but someone else lives on, the copyright will remain effective for 70 years after the death of the remaining author. And then also the terms for works made for hire are the same for anonymous works or pseudo-anonymous works. So, if you have a work that the author is unknown, it's going to follow a works made for hire term. And again, if you have special circumstances or anything of that nature, like in that, I really encourage you to go to the U.S. Copyright Office website at copyright.gov for more information in calculating and determining exactly how long the work in question's copyright will last. So how much does a copyright cost? Well, compared to other areas of intellectual property, copyright registration is really substantially lower than the other IP tools. And that's because, the registration itself paid to the Copyright Office is typically $45 for single work authors and $65 for works made for hire and or joint authors. And if you get the assistance of an attorney to help you file for copyright registration, the average is usually $250 to $500, and it can be more in certain circumstances. But that's just kind of a general ballpark range for you to consider. So as you can see, they're relatively inexpensive. So, for the benefits that you gain from registration, it's definitely worth the price of, seeking that registration. So one of the things that we were talking about within the bundle of sticks analogy was that you can hand a stick to someone else, giving them the right to distribute the work or reproduce the work. Well, how is that done? That's typically achieved through what we call a licensing agreement, which is a right that is assigned to a third party, giving that third party the right to do certain things that's specified by the agreement itself. So essentially that third party can use a mark that's owned by someone else, but the mark's original owner retains the copyright. So you're not actually transferring ownership. You're just giving, essentially, you can think of it as a lease or a temporary right to use the mark, but you're retaining the original copyright itself. And another thing that's common with licensing agreements is that the owner may require royalties. And royalties are typically a percentage of the net revenues generated and associated with the use of a mark. So here, if you're a business and you license out your mark to someone else to use, you may require them to pay you a percentage of their net revenues that they generate from using the mark, in addition to whatever fee they're paying you to use the mark to start with. So you can see that licensing agreements can be really beneficial, and they can be a really powerful tool, especially for businesses that have developed, pretty well-known brands or things of that nature, or works themselves are really famous. So, really in the licensing context, the best example I can immediately give that most people will understand is that in music, if you have certain music, you have to have a licensing agreement to publicly perform works that are protected. And here you get that right through the licensing agreement. If I record a derivative work or kind of a cover of a song, and I commercially market that song, it's typically going to require that I pay royalties to the owner of the original copyright. So you can kind of see there why licensing is so important to copyrights, and it's very again, a very useful tool for the owners to monopolize their IP or their copyright in this instance. So what is an assignment of copyright? Well, an assignment is when you are actually transferring the ownership. And the copyright can be transferred entirely to a new owner through assignment. But there is a requirement here that for you to transfer the ownership via assignment, it must be made in writing, and it has to be signed by the owner of the rights. So, here think of if I develop a poem and someone else wants the rights to my poem, I can easily assign them the rights to my poem. So long as it's in writing, I sign the work, and then I can receive payment in exchange for giving them my rights to the copyright. And here also a copyright assignment can also be made via a will or probate. So that means that if I own a work and I die, my estate will take ownership of that work, and they can transfer via assignment the work to someone else later on. Or, if I have a will, I can designate that my rights in that poem go to someone else and specify who that person is, and that shows it being transferred via will. So there's kind of also a really common pitfall that we see a lot, especially with small businesses with copyright assignment, and that is that small businesses will often hire graphic designers to do various projects. So it may be something like drafting a brochure or developing a logo for you, for example. And this is kind of a common one that we see, is that if a graphic designer makes a logo for you, you pay them to do that, but then they just give you the file at the end. Well, if you don't have an explicit agreement that's assigning the copyright to that work, that graphic designer still technically owns the copyright to the work in certain instances. So here you need to always remember to get a copyright assignment from your graphic designers or other parties, just to ensure that you truly are owning the right to do whatever with the work that's produced for you. So again, this is something that we see a lot. So try to always remember that, especially when you're engaging with graphic design work. So what is copyright infringement? Well, looking at this picture here, you can see notably you have the Nike shoebox that has fake written on it. Well, that really epitomizes what copyright infringement is. Copyright infringement is taking someone else's work and either replicating it, like making fake copies of the work, or it can even be just simply copying the work, claiming it as myself, or selling it, or selling the work and not properly compensating authors. It really, infringement is really a broad definition. And the actual definition of it is the act of using, copying, and or distributing copyrighted works without authorization of the copyright owner. And, you know, important to note here is that intent or knowledge is not a defense to copyright infringement. So, you know, in other words, ignorance is not an excuse. Just because you don't know that you're infringing when you're copying or using a good or a service or something of that nature without authorization of the copyright owner, just because you don't have that knowledge that you're doing that, it's not an excuse. So you should always try to be cognizant of copyright infringement and, you know, and thinking about, okay, well, am I using someone else's copyright without permission? So kind of with that, you're probably thinking, well, what are some common infringement activities? One of the most common ones is photocopying literary works. So if you have a textbook and you go copy portions of that textbook and you're distributing it out to individuals that would be purchasing the textbook otherwise, that may be a form of infringement. Photocopying sheet music. This is something that we see a lot, especially with religious organizations. They think that they can just go copy the sheet music, buy one version of the book that contains the original, copy it for everyone else, and that is often, in most cases, copyright infringement as well. Illegal downloading of music and movies. So this is something that, you know, is really, it was really predominant, especially about 10 years ago, with the age of LimeWire and Napster, which were peer-to-peer music networks online, where individuals would share music or share files containing music or movies and things of that sort. So there, you know, obviously that's copyright infringement because you're not, number one, you're distributing the work without permission of the copyright author, and then number two, it's damaging the copyright owners because otherwise they would be receiving compensation. So you can kind of see there, downloading of music and movies is really a big issue. And it's something that we really see heavily enforced, and enforcement really is stepping up even more as we move forward in time. So, you know, a lot of times you're going to see that internet service providers are somewhat watching for this. If they receive notice that someone on their network is illegally downloading music or videos, they'll mail a letter to that resident saying that, you know, infringing activities have been taking place, and they essentially give a warning of that. But obviously, if the illegal downloading is prolific, there's certainly repercussions there that the copyright owners can pursue copyright infringement claims against the individuals. Another common infringement activity is selling counterfeit goods. And, you know, this happens all the time. And this is something that has been a real problem, especially with the development of e-com. And what I mean there is platforms where individual sellers can set up shop and start selling their products online. So there, you know, you have real problems with platforms such as Amazon and eBay, things of that sort. And, you know, we've really seen Amazon taking several steps here recently to kind of stop or minimize the sale of counterfeit goods on their marketplace. But, you know, it's so prolific. And oftentimes we as consumers may be actually transacting in counterfeit goods and not even know it ourselves. But here again, you got to remember that ignorance is not bliss. So, you know, in terms of copyright infringement, the intent or knowledge is irrelevant. So you can see where that's a common infringement activity. Also, the covering of a song without paying royalties. This is something that we really see a lot of as well. So individuals, whether they're publicly performing that, whether it be at a restaurant, a bar, anything like that, they may or may not be properly paying the royalties to the copyright owners of that work. But also, you know, if I cover a song and post it on YouTube, you know, in certain instances that I should be paying royalties to the copyright owners unless that's done through some other form of licensing agreement. But you can see that this is a common activity as well. So there's really a lot of different myths floating around surrounding infringement. And really, you know, and we're going to be talking about these 3 examples of common myths, and these are all very much false. You know, so like the most common one that you'll hear with respect to music is the 30-second music rule. And that just means that individuals will say that, oh, if I use only 30 seconds of a copyrighted song, it's not infringement. Well, this is not true, you know, because it doesn't matter the amount of the copying that's done. It does not matter. If you use any direct copying of a copyrighted work, that is infringement. Another common one is that you'll hear the 10% fair use rule. And this is kind of conflating 2 different topics here. So, or 2 different issues are going on at the same time. So you have, you know, you're saying that is as long as I'm using less than 10% of the copyrighted work, it's not going to be infringement. But also you'll see that the term fair use is thrown in there. And there's a lot of confusion in the general public about fair use because people will say, oh, I can do this through fair use. Well, as you're going to see later in today's presentation, fair use is very narrow and its applicability. So again, the 10% fair use rule doesn't exist either. Last, anything without a notice is not protected. And this kind of stems from kind of a misconception. So prior to the enactment of the 1976 Copyright Act, there were some mentions of requirements of notices, but we don't have that. So, you know, as we said, copyright exists at the time it's first recorded. So obviously you're not going to have a notice on there of that work. That doesn't negate your copyright. So you can see there that anything without notice, that's simply just not true. So now let's jump right into a pop quiz. So true or false? John, a professional photographer, captured what has now become an iconic photograph of a national park approximately 2 years ago. John never registered his photograph for copyright protection. A company began selling his photograph on canvases roughly 1.5 years ago without his permission. John can bring suit against the company for copyright infringement today. True or false?
And Sandeep says that's true. Sharita votes false.
So here, the answer is actually false because first, in order to pursue copyright infringement claims, you have to have federal copyright registration before you can ever pursue that form of litigation. There's also a potential issue here that even if he had obtained registration, he knew about if he knew about the infringement and chose to do nothing, that's, you know, for a set period of time, that can be a potential issue as well. But here the answer is false, primarily because you have to have federal copyright registration before you can pursue litigation. So you heard me mention fair use, and there's a lot of misconceptions surrounding that. So what is fair use? Well, the fair use doctrine is something that permits you to use copyrighted works without the owner's permission for purposes of criticism, comment, reporting, teaching, scholarship, or research. And you can see here, these may sound like broad terms or broad strokes, so to speak, that you can use it for fair use. That's not the case. These are actually fairly narrow categories of fair use. And as you'll see, fair use is entirely judge determined. So there's no clear-cut rule. So, another way that I like to think of fair use is nothing is a fair use until a judge says so. And obviously you don't want to be in a situation where you're in the situation where a judge has to tell you it's a fair use or not, because that means you are in litigation at that point. So courts really use the 4 factors in determining fair use, and those 4 factors are the character of the use, whether it's commercial or for nonprofit educational purposes, whether the work is more creative or factual, and the amount of the work used in relation to the work of the whole, and whether the use causes potential economic harm. So you can kind of see there that those are going to be the 4 factors that are usually looked at for fair use doctrine. And this is a balancing test, so it's looking at the answers to all 4 of these rather than looking at them individually. No single component of this or a single factor weighs more heavily. So some examples of where fair use has been found would be like playing movies or music in the classroom for educational purposes only. Library digitization of printed materials, so taking printed matter, scanning it in, making it available electronically for a library is fair use. Parody, such as comedy shows like Saturday Night Live and South Park. Those have both been found to be fair uses of copyrighted material. So with that, let's kind of recap our important takeaways from copyrights. And first, copyright exists at the time the work is first physically fixed. And this is very critical because it has to be physically fixed, meaning you can share it with someone else. Second, copyright includes several rights which can individually be used exclusively by the author. They can also be sold, or they can even be leased. So here, think of the bundle of sticks analogy. Copyright has all these different rights that each may be a stick within the bundle. You can pass out separate sticks. Last, registration, or third to last, is registration is important. And registration, as we've already said, not only does it give you the potential, if it's done timely, for more access to remedies, such as statutory damages and attorney's fees, things of that sort, but also you have to have a registered copyright to pursue an enforcement action for infringement claims. Last, be aware of potential infringing activities. As you've seen here, infringement is very common, and the critical takeaway from infringement is that knowledge or intent to actually infringe, it doesn't matter. It's, infringement is infringement. It's just as simple as that. So as I've mentioned, we have one upcoming workshop left in this 4-part series, and that's going to be on July 15th at 1 p.m. And that's going to be covering patents and trade secrets. So we hope that you'll join us there. Also, we are releasing toolkits, which are written guides diving more in depth to each of these areas that will be accompanying the presentation series. And then we're also going to have IP primer videos, which are walking through the toolkits and giving you all the information that you need to know about each of these areas. So we hope that you'll keep a lookout for the toolkits and the videos that are going to be accompanying this workshop series. And last, if you have any questions or want any more information, strongly recommend that you visit. For copyright, obviously you want to go to the U.S. Copyright Office website at copyright.gov. For patents and trademarks, you want to visit the United States Patent and Trademark Office website at uspto.gov. And of course, if you want more information about ASBTDC or the Business Innovations Clinic, our links are provided here as well. So with that, thank you so much for joining us. Hopefully you've learned a lot from today, and now we'll take a look at questions.
All right, thank you, Brett. As you did last week, another interesting presentation. We did have a few questions submitted. One is by Sandeep, and this is generally for everybody. He was asking if he could get a link to the YouTube video on trademarks from last week. I'm going to make sure everybody gets links to all 3 videos. So you'll get a link to today's video plus the 2 videos we had last week, the general introduction and the trademark video. Destiny asked, would anime be considered under motion pictures?
Professor Vu-Dinh, do you want to take that question?
You know, you caught me off guard with the anime. I don't know that 100%, but just thinking through that, it's an audio visual, it's, you know, a certain length of time. I believe you would qualify as motion picture. Either way, it's copyrightable. The categorization, I can't say offhand. Another thing I will mention is that when you are going through this process, the USPTO office actually is incredibly helpful in making corrections, not for patents so much, but for trademark and copyright. And their resources are really good to figure out how they want things categorized.
All right, and Sandeep had submitted a question, which I think got answered a few moments later, but he had asked, what would specific company and product names fall under copyrights? And I believe a few moments later, you mentioned, you know, company names and brand names would be trademarks.
Yeah, so there, you know, remember that if you have a brand name, like a company name or even a band, like a musical band name, all of those are going to fall under trademarks. And also remember that slogans fall under trademarks as well.
Okay, and Sandeep's last question here, and the last in our queue, was how will copyrights apply to business technical inventions or innovations? You know, and I'm thinking this is like plans, instructions, diagrams on how to operate, that sort of thing.
So as kind of assuming that I'm understanding the question correctly, if you're talking about technical inventions or things of that sort, generally that's going to fall under patents and or trade secrets. But there is some overlap. So like if you're talking about the design of something particularly, it may be eligible for both trademark and or patent protection in certain instances. So I think that's what you're referring to there, but Professor Vu-Dinh, do you have anything to add to that?
Yeah, I think that is a pretty thorough answer. I think the big picture importance is distinguishing what copyright protects versus what patents protect, right? So copyright, it protects that precise work as you have written it. It doesn't protect the ideas behind that or what the thing is talking about, right? So if I personally write a book or write an article on antitrust in farming, that's not stopping anyone else from writing on that topic. It stops them from photocopying my work. Patents, on the other hand, that's where you have a prevention of the duplication of a process, okay? Or using a trade secret contract. That's where you might stop the actual use of that idea that's been protected. So just keep those two distinctions in mind as you are going about your business or consulting others.
All right, that empties our queue, and with that, I think that ends our webinar. So I do want to thank everybody for being with us. Again, you can reach out to ASBTDC at 800-862-2040. We're on Facebook and Twitter. Your video will be up this evening by 5 o'clock on our YouTube channel. As always, ASBTDC is a partnership with the U.S. Small Business Administration. UA Little Rock has the contract for that, and we partner with 10 additional universities around the state, covering all 75 counties. So somewhere near you is an office that we hope is physically going to be open this fall. to assist you with your small businesses. And we're still doing everything virtually for right now.